And so we have an order that hasn't been followed. I mean, Mr. Whitney, if you show to the court satisfaction that for reasons beyond the D.E.T.R's own doing or own making, it was unable, as opposed to unwilling, but unable to abide the court's order, it seems to the court this is asking for forgiveness rather than permission, which is really not the best approach. We are on the record in the case of Amethyst, Payne, and others versus State of Nevada, Department of Employment, Training, and Rehabilitation, et al., as we have been referring to it as the D.E.T.R case. This hearing today is occurring consistent with Nevada Supreme Court Rule Subpart 9 on hearings being conducted via simultaneous audiovisual transmission and various administrative orders of Nevada's Second Judicial District Court, which have essentially closed the courthouse to in-person hearings on account of the global COVID-19 pandemic. We have previously had hearings in this manner, and I don't anticipate any logistics issues that would interfere. I'm Judge Breslow, presiding judge in Department 8, and I am actually appearing from the Washoe County Courthouse from chambers. At this time, I ask counsel for petitioners to please identify themselves and confirm they can hear the court, starting with Ms. Jones. Good morning, Ms. Jones.
Good morning, Your Honor. This is Leah Jones for Plaintiffs Petitioners, and I am in Washoe County, Nevada.
Thank you very much.
And I can hear you.
Very good, thank you. Co-plaintiff counsel, Mr. Thierman, good morning.
Good morning, Your Honor. This is Mark Thierman, and I am also in Reno, Nevada.
All right, very good, thank you. For State of Nevada, let's start with Mr. Ott. Would you?
Greg Ott for the State of Nevada, and D.E.T.R calling in from Washoe County, Nevada today. I can hear all parties very well so far.
Very good, thank you. Mr. Whitney, good morning.
Good morning, Your Honor. Good morning, everyone. This is Robert Whitney, State of Nevada, in Clark County, Nevada. I can hear everyone fine. Thank you.
All right, very good. Thank you. And then who would like to identify the administrator of D.E.T.R, or actually ask the court would ask her if she would mind to please turn on her camera and identify herself.
Good morning. This is Elisa Caffaretta, and I am the director of D.E.T.R. I am in Reno, Nevada, and I can hear all parties. Thank you.
Very good. Thank you so much. All right, let's go over a few things preliminarily, because as everyone is aware, this is the time and date set for a hearing on petitioner's motion seeking the court to hold the state in contempt of the court's prior order of mandate, directing that payments resume consistent with the prior order of the court. The court wants to mention a few things with respect to how the hearing will go this morning and a few related matters. Let's start with the related matters. For those of you watching at home who are not directly parties to this case, I encourage you, notwithstanding your very close and understandable interest in what happens here, but please refrain from emailing the court directly or any of the court's staff. Department 8, my department, has been receiving numerous direct communications from people who would like the court to know of their experience and their story. And while generally that type of information may have relevance to what we're doing here, it cannot be done in the manner in which people are doing it, which is to communicate directly with me or any of my staff. So I encourage you to stop sending emails and information to the court, because we do not review and consider that. We glance quickly to see what it is, and once we recognize that it's a document that ought not to be sent directly to the court does not consider it, does not impact the court's decision, and in fact, the court usually will either return it if it's mailed or if it's emailed, it will be stricken. So please do not communicate directly with the court. Also, the court clerk's office has received at least one what's identified as an amicus curiae brief, a friend of the court brief with respect to these proceedings. Again, although the motive and intent of having the court understand better what's happening with that particular person, it's not the type of document that can be considered by the court. Indeed, amicus briefs generally are not proper to be filed in district court actions. They are for appellate actions. And even then, only with court permission or agreement by the parties. Indeed, the court is aware that an amicus brief has recently been filed by Nevada Legal Services with the permission and consent of both sides here in a matter before the Nevada Supreme Court. That's how you do it. You don't file amicus briefs in district court. So to the extent that any have been filed in this matter, the court strikes those as improperly filed. Again, I'm not commenting on the substance. I'm not suggesting that the person or persons who are filing them don't have issues that need to be understood and possibly addressed. But this is the wrong form, the wrong time, and the completely wrong procedure. So please do not file or attempt to file any more amicus briefs in this case directly. All right, that's 2. 3. What is the status, please, Mr. Ott or Mr. Whitney, of payment of the first tranche of the special master's professional billings that the court directed to be paid on or about November 15th? Who would like to address that? Okay, I'm going to call on Mr. Ott. Do you have an understanding of the status, please?
I do not have a current understanding. I did have contact with the special master and asked him to get a vendor account established so that he could get that processed. My understanding is that everything has gone forward. I have not heard otherwise from the special master, but I will work on getting confirmation from that so that I can relay it to the court later on during the hearing, if that's acceptable.
I would appreciate that. And as well, if you would please file a notice with the court indicating that the first billings of the special master have been paid once you receive confirmation that payment has been made and received by him. I'm hoping that that can be filed this week because he's been paid. Directed he be paid on or about November 15th. But if there are reasons that it's in process that have delayed the process, I can be notified of that as well. But I'd really like there to be a filing by the state that says something like notice to the court that the special master's first billings payment has been made and received. And then the second one, as I recall, was ordered to be made no later than on or about December 30, 2020. So again, once that payment is made and received, Mr. Ott, if you would please file notice of that with respect to that matter. If the court believes that there's undue delay or delay without good cause, then the court will have a hearing and we'll get to the bottom of it. But Mr. Guanasso and his team greatly assisted the court in understanding the issues and providing background information and facts that assisted the court in its determinations in this case. So I want to get that buttoned up and please make it happen. All right, next. It's come to the court's attention that either one or both sides here would like to exercise the rule, invoke the rule of exclusion so that witnesses that have not yet testified today will not be reviewing, listening, or monitoring testimony before them. So it does not indirectly color their recollection or testimony. So let me start first with petitioners. Will the petitioners be invoking the rule of exclusion?
Yes, Your Honor. The one question I do have about that is if there's going to be any cross-examination and calling a witness back. I'd like to let our witnesses go after they have testified. So I just wanted to find out from the court and from defense counsel what their preference is so that our witnesses can be aware.
All right. Well, that's a good question, and we'll talk about that in a moment. But I want to take the crossing one bridge at a time. So right now, rule of exclusion. If either side invokes it, the court orders it. So, but just for the record, Mr. Ott, Mr. Whitney, with the state otherwise being invoking the right, the rule of exclusion with respect to the petitioner's witnesses.
Your Honor, this is Robert Whitney. Yes, we would please invoke that rule.
All right, so let's talk about how logistically that happens in a Zoom hearing like this. So first of all, let's remind ourselves how it works if we were in the courthouse. If we were in the courthouse, witnesses who were expected to be called or otherwise under subpoena in the event of a party invoking the rule of exclusion would be directed to wait outside in the hall. And the court bailiff would call them in as their turn came up. And after they were done testifying, and if counsel agreed, they could be free to go and not be subject to be recalled. They could leave or they could stay in the back of the courtroom and watch from that point forward. It's more difficult to monitor that in a remote hearing like this. What we have is potential witnesses for the petitioner, potential witnesses for the state. They're logged into this Zoom hearing, presumably. They're watching, and when it's their turn to testify, I will direct my court clerk to bring them forward to be sworn and to respond to questions from both sides and maybe from the court. And then if we agree to release them and not subject to be recalled for rebuttal or other purposes, then they're free to go. But it's very difficult to monitor them as being virtually out in the hall because they can be linked in and watching. And that, of course, subverts the rule of exclusion in the first place, which is designed to prevent people from observing other people's testimony with the goal of having them testify as to their own recollection, memory, and experience, and not piggyback on somebody else. So the way we've been doing it is this, and it's a bit unwieldy, but I cannot think of a better, more effective way. And that's this, counsel. The witnesses that you expect to call need to not be observing this court hearing until they are summoned to log on and then be called to testify. So what that means is, Ms. Jones and Mr. Thierman, because petitioners will be going first, is by your emailing to them or texting to them or this court's directive right now here in open court, they're all to log off this hearing. And I want to get the names of all the witnesses. I know you've each filed a notice of expected witnesses, but I want to make sure that my court clerk has that handy. And so she can tell if any of them are logged on and watching this hearing, because if they're expected witnesses, they should not be. Then when an attorney calls their witness, they won't know they're being called because they're not watching. So Ms. Jones or Mr. Thierman, one of you or your staff has to reach out to them quickly and say to witness number one, okay, it's your turn. Please log back on to the Zoom hearing. Once my court clerk sees that they are on the Zoom hearing, we bring them into the panel discussion and they testify. But until and unless they receive a communication from their lawyer that it's their turn to log on, they don't watch what's happening. They don't watch what's happening. And then same with the state's witnesses. They don't watch this hearing at all until and unless it's their turn to testify, in which case somebody from the state communicates with the witness logs on, they're called to testify, And when they're done testifying and they're released, then they can be in the background watching like everybody else. That's how we do effective sequestering of witnesses in the virtual courtroom situation that we're experiencing. So with that knowledge now, Ms. Jones and Mr. Thierman, let's start with you. Do you still want to invoke the rule of exclusion if you understand how it's going to work?
Your Honor, thank you. This is Leah Jones for Plaintiffs. I'm not concerned about the state's witnesses listening to each other. It might be a good idea so that they can hear what their colleagues have talked about in case.
Ms. Jones, I'm not trying to be rude, but I got to move this along.
Sure.
Based on what you just heard, yes or no, do you still want to invoke the rule of exclusion? Because I've just told you how it's going to go. How it's going to go is all 16 or 12 or 20 of your witnesses cannot be logged on, and you or Mr. Thierman or your staff is going to have to reach out to them one by one and bring them in. Do you want to do it that way? Do you not want to, or do you want to think about it a little more? And I'll ask the state.
I have 3 witnesses. If the state wants to exclude them, we will have them log off and we'll have our assistant call as they are ready to testify and have them log back in. I don't need to, I'll waive the exclusion for the state's witnesses.
Okay, well then let's talk to Mr. Ott and Mr. Whitney. Now that you've heard that the petitioners will waive the rule of exclusion, and it sounds like they're politely asking the state to reconsider on account of, number one, they only have 3. Number 2, they're willing to waive it as to your witnesses. And number 3, you've just heard from the court how the approach would have to be for each of your witnesses or each of the petitioner's witnesses. So having heard all that, let's start with you, Mr. Ott. Would you like to reconsider your invocation of the rule of exclusion or stand by it? It doesn't matter to the court either way.
Thank you, Your Honor. Mr. Whitney will have the lead in presenting the case today, so I'll defer to his judgment on this.
Thank you. Mr. Whitney.
Your Honor, I'm sorry, I thought I was muted for a moment. I think based on what the court has said, the minimum amount of witnesses, what they're going to testify to, I don't think we will not invoke the exclusionary rule.
Perfect. You've made it much easier than on the logistics for the court, and I appreciate that. And please understand that, I'm not trying to back anybody off of their view, their position, their strategy. But the reality is how I've just said, because unlike in the courtroom, we can't tell if somebody's walked into the courtroom, and like we could if we were here in person. All right. So the rule of exclusion is not invoked by either side. All right, let's move on. Okay. Who can apprise the court? So we have, each side has taken an appeal. The appeal was dismissed. Then the court understands that each side has now re-appealed, and there is expedited briefing, or is that on a writ petition that the petitioner has filed and in which the amicus brief has been filed as well? Mr. Thierman, what's the status, please?
We filed our opening briefs. I believe their state's briefs are due in about 2.5 weeks or so. And that's basically, it's not a writ petition itself. It is a appellate appeal from your order, or your denial and grant in part writ.
Got it. And that's what the Nevada Legal Services has filed its amicus brief in. Is that
Yes,
right?
Your Honor.
All right, thank you. Mr. Otter, Mr. Whitney, do you know any differently?
Your Honor, I do not. It's actually a different unit in our office is handling that appeal. Mr. Ott may have more knowledge on it than I do. But
No, Your Honor, nothing to add to what Mr. Thierman said.
All right, thank you. And the reason I ask is because as we've covered this ground before, while the initial appeal was pending and cross appeal, and before it was dismissed and refiled, the court is divested of jurisdiction on substantive matters. The court has previously determined that it has the authority as part of its ancillary jurisdiction that remains, notwithstanding the appeal, to both monitor fee applications like those submitted by the special master, as well as to enforce its prior order of mandate, which is why we're having this hearing today. But in all other regards, all other material regards, substantive regards, the court believes it is divested of jurisdiction, and that's why this case will not currently be proceeding other than with respect to matters the court has retained jurisdiction on. Does anybody believe it's other than that? Ms. Jones or Mr. Thierman? Seeing shaking of the head. All right, Mr.
No, we agree with you.
Thank you, Mr. Whitney. Any comments in that respect? No. All right. Then let's get to the hearing. The petitioner is asking the court to find the state in contempt of the prior order of mandate. The briefing, the initial briefing and some supplemental briefing by the petitioners indicate that they believe there has been some level of compliance, but not complete unbridled compliance with the court order. And they're asking the court to hold the state today to answer to that concern and to, in the mind of petitioner, demonstrate to the court's satisfaction that there has not been compliance, substantial compliance, or failure to comply with justifiable excuse, and thereafter to hold the state in contempt. So the order of proceedings will be, I'll hear from each side, starting with petitioner, then the state, a very hopefully condensed summary of what they believe the evidence will show today, and then as well advise the court in their opening what they're asking the court to do. Obviously, the court is aware that the state is going to ask the court to deny the order to hold the state in contempt. That's an easy one. But with respect to Mr. Thierman and Ms. Jones, in the event they've convinced the court that the state is willfully violating the court's order of mandate, I want to know what exactly the remedy is that you are asking for and which statute or rule of procedure you believe entitles or authorizes the court to make such a determination. So let's start with petitioner. What will the evidence show today? What are you asking the court to do? And what authority do you base your request on? Who will speak first, please?
Good morning, Your Honor. This is Leah Jones for Plaintiffs. D.E.T.R has already made multiple admissions that it has not complied with your July 22nd order. Your order was quite clear in that any applicant who had received a payment could not have payments withheld unless A, they did not file a weekly claim, B, the applicant had earnings in excess of what would have otherwise qualified the applicant for benefits, C, there was clear and convincing evidence of fraud, or until such time that the applicant was afforded an opportunity to be heard. Payments to these applicants was supposed to commence on or before Tuesday, the 28th of July. No applicants were actually paid by that date. An order from the court is not optional. Partial, even significant compliance is not actual compliance. A full month after the deadline of July 28th passed, on 8/31, D.E.T.R made the admission in their opposition to plaintiff's motion for contempt that full compliance of the July 22nd order and the time allotted was not possible, and it actually resulted in harm to the applicants. This harm continues for a universe of applicants who are subject to your order of between 11,741 to 22,036 people. During this hearing, plaintiffs will provide testimony from 3 separate witnesses that meet the court's requirements. And they have provided their portal documents as partial exhibits or exhibits for the court and D.E.T.R to look at to see that they do meet those requirements. These witnesses, these 3 witnesses, represent 11,000 to 22,000 real people who in many cases have not received any benefits for over 6 months. They should have been paid. They must be paid pursuant to the court's order. Plaintiffs request that D.E.T.R be held in contempt, and under NRS 34.290, that D.E.T.R is fined $1,000 per occurrence, and that if the court seems or feels that it's just, that a civil or criminal penalties should also issue. That is what plaintiffs are requesting today.
Thank you. Before I hear from the state, Ms. Jones, the $1,000 fine contemplated by Nevada Revised Statute 34.290, you mentioned per occurrence. So first of all, are you certain the law envisions per occurrence? And second, what's your definition under the unique facts of this case of what per occurrence means? Do you mean per person? Do you mean per week? Do you mean per day? Do you mean what? How exactly do you define per occurrence, please?
I apologize, Your Honor. That was ambiguous term. It is our understanding under the statute that each person held responsible, each person, for instance, the director of D.E.T.R, the administrators are fined. We do not believe that D.E.T.R should be fined $1,000 per, for instance, if it is indeed 11,000 people, that they should be fined $1,000 for each of those people. I do not believe that that's what the NRS contemplates in that case.
All right, thank you. Then with respect to a further penalty, if the court finds justification, what are you suggesting the court invoke its authority under civil contempt, criminal contempt, or both? And if so, what remedy would that be? Because as the court understands, usually, even if the court is convinced after today's hearing that plaintiffs have proven that the state without just cause has failed to abide the court's order of mandate, the penalty would be $1,000 fine, and then further orders of the court to recheck at some time in the very near future to see if there's continued failure, and only then for the court to take it to the next step. Because as I think we're all aware, the court has authority to put somebody in jail if there's willful noncompliance with a court order, if the person has the ability to comply and is failing to do so. And that's the classic case of giving the incarcerated person the key to their own jail cell. But that seems to the court to be an extreme remedy only in the event the court finds today that there's been a failure to abide the court's order without a legal excuse, and then B, given additional time to comply, and then an abject failure, that would be a possible remedy. Do you agree, Ms. Jones, or is that, do you disagree?
No, Your Honor, I do agree. I don't believe that the statute allows for the $1,000 per person. Per occurrence, I guess, if you could say. But we had asked in our motion for contempt for you to publicly admonish D.E.T.R for their failure to comply with the court's order. As far as the jail term, I believe that is part of a criminal contempt motion. And one of the cases that defendant cites to the Falstaff case talks about whether it's a civil contempt or a criminal contempt, and it turns on whether the contempt or has the actual ability to comply with the order. We believe they have, and so I think that if the court decides that it would be possible to have a criminal contempt and place somebody in jail. Again, you mentioned the willfulness, and I think that goes to the fact of whether they have the ability to. If they have the ability to comply with the order after you hear the evidence today, not just that it's taking them too much time or they don't have enough staff or some other excuse that isn't actual inability to comply with the order for some reason. I think that a criminal contempt and jail time would be warranted here. But at least if after the evidence is heard, if the court, in addition to the $1,000 fine, would also admonish D.E.T.R and let the people out there know that the court is willing to hold D.E.T.R's feet to the fire, so to speak.
Okay, thank you. All right, who would like to address the court from the state as to what they believe the evidence will show here? And then, although I am well aware that they strongly disagree that an order of contempt should issue, what they believe an appropriate response from the court should be in the event the court believes there's been a willful failure to abide its prior order. Mr. Ott, will you be speaking to that, or Mr. Whitney? Mr. Whitney.
Thank you, Your Honor. One thing, just really quickly, we do want to put on the record, I don't know if this is the time, we do object to the 3 witnesses testifying. Again, it's kind of a standing objection. I believe the court's aware of it because, again, there's these people are not the listed witnesses. It's proceeding as a class action, but there's been no class that's been certified. Moving to your specific question, Your Honor. We're here today to show that there was no way that D.E.T.R could comply with the court's order of mandate by the date set, which was July 28th of 2020.
Hold on one second. Sorry to interrupt you before I forget. Where was the motion for a stay? Where was a motion to reconsider? Where was a motion by the state for the court to amend its order to change the date? I don't remember having that motion brought before the court, briefed and decided. And if there wasn't such a motion, Mr. Whitney, why wasn't there?
Your Honor, I don't believe that there was such a motion that was brought before the court.
Let me get real here. If in a civil action, if there's a court order directing someone or some entity to do something, and the entity intends to comply, but then finds that they're unable through no fault of their own to comply with a court order, they don't ignore it. What they do is they ask the court to stay its enforcement of it, or they ask the court to amend it, or they ask the court to modify it, or they ask for a hearing to explain the efforts they've made and to get the court to agree that they will not be held in violation of the order if they fail to do it. But, right now I see the the plaintiffs saying, none of that happened, Judge. And so here we are months later, and so we have an order that hasn't been followed. I mean, Mr. Whitney, if you show to the court satisfaction that for reasons beyond D.E.T.R's own doing or own making, it was unable, as opposed to unwilling, but unable to abide the court's order, it seems to the court, this is asking for forgiveness rather than permission, which is really not the best approach. But anyway, so there's an objection to the 3 witnesses because they're not named plaintiffs. The case has not yet been certified as a class. There's been no motion filed to the court's understanding asking the court to amend or change its prior order, although the court is aware the order is on appeal. What else do you believe the evidence will show today?
Your Honor, I believe the evidence will show that D.E.T.R is in substantial compliance with the court's order. Can we say that it's in full compliance with the court's order? Probably not. But we are asking the court to hear the reasons why claimants that started to get paid by the payment was stopped in those cases. We believe that the evidence is going to show it's really a combination of reasons. It took D.E.T.R a while to get staffing going. Again, the claims were overwhelming in number. And also the fact that, again, as the court recalls, there was an agreement to implement P.U.A benefits that was signed some time ago by Administrator Kimberly Dodd near the end of March. Again, D.E.T.R agreed to follow USDOL guidance, and USDOL guidance in some cases is going to result in D.E.T.R not paying claimants where the payments has started, but then stopped. Again, I think the biggest example that the court has probably seen or is familiar with is the situation, because it's been presented at least once before. I can't remember exactly when, but where, for example, UPL 1620, if you have a claimant that's being paid in P.U.A but then becomes eligible for unemployment insurance, extended benefits, the pandemic emergency unemployment, then payments there have to be stopped. And there's other situations too where that guidance says that D.E.T.R has to stop paying people. And those would be reasons other than what the court's order mandates. So we'd ask the court to hear those reasons out. We also are prepared to respond. The court had mentioned that, of course, it's heard the 3 witnesses. We do have someone that's prepared to respond to their allegations here today. And we would ask that the court deny the petitioner's request here to find D.E.T.R in contempt, not only because D.E.T.R is in substantial compliance, but the court probably recalls defendant's argument that 34.290 calls for personal service. It doesn't call for service by electronic means. Notice is not personal service. There's case law citing that. We've cited to the Avro case. So it would be appropriate for the court to deny the motion for contempt in this case.
Okay, and again, I don't want to get too much into what the evidence showed and what the ultimate decision of the court should be. That's going to be for argument at the end of the evidence. But just to frame some of the issues the court has been considering, I've already mentioned a few. But Mr. Whitney, you heard Ms. Jones indicate that the plaintiffs believe that the evidence will show that between 11,741 people up to, at the low end, up to the high end of 22,036 people who otherwise should have been paid pursuant to the order of mandate have not yet been paid. Do you, with respect to those numbers, are those numbers you've heard before, seen before, or are you hearing them for the first time? And because does the state agree that that's the range of people, and then you have an explanation as to why they haven't been paid, or does the state have a different range of people?
Your Honor, we do have a different range of people. That's actually going to be presented in the testimony here today.
Well, what do you think the range is? What do you think the evidence will show in that regard?
Your Honor, from the documentation I have, it appears that it's the range might be a little bit larger than that amount, than the 10,000. But again, we are prepared to show why these people have not been paid.
All right. Well, I'll save my additional thoughts for later after I hear the evidence and hear further argument.
Must be an evaluation of the best interest.
You're going to convince me to hold your client in contempt.
Raise your right hands, face the court clerk to be sworn.
Sitting judges pay contempt wrong all the time.
I find you in contempt. I am going to incarcerate you.
Pursuant to that Supreme Court ruling, your debt penalty qualified.
Please put in writing your concerns or objections.
Any statement that you make is under penalty of perjury.
All right, at this time, Ms. Jones, would the plaintiff please call their first witness, identify their name, and then I'll ask my court clerk to bring them onto this meeting and be sworn.
Thank you, Your Honor. Plaintiffs would like to call Heather Boyd, B-O-Y-D.
While we're waiting for that, Mr. Thierman and Ms. Jones, you've heard, again, from Mr. Whitney and from the state, their objection to the court hearing evidence from people that are not named plaintiffs from the, I'm going to use the phrase, putative class. And this is ground we've covered before as to why the court issued, a writ that had statewide reach, and the thoughts of the court on that this is one of those unique cases where the alleged harm is capable of repetition yet evading review. But I want to make sure, Ms. Jones and Mr. Thierman, nothing has changed from the plaintiff's view that the court is authorized to continue thusly, because we can spend all this time and you might get the relief you're seeking today or later. But if 4 out of 7 justices, if they all hear it, or 2 out of 3, if they hear it, decide that this court lacked the jurisdiction to proceed as though this case was a putative class or had other exceptional circumstances to allow this type of relief, then this has been an interesting intellectual exercise, but didn't actually accomplish anything for plaintiffs. So, have you reconsidered? Are you doubling down? Do you stand by the position you've previously taken? Because, I want to make sure that your belief and the record are clear as to why the court has authority to go forward in this manner, notwithstanding the objection from the state. So, Mr. Thierman.
Yes, Your Honor. And in the normal case, if the writ was brought to invalidate a statute and it was granted, it would invalidate the statute for everybody. The same thing applies here, that you ordered D.E.T.R to do something. It's not just these 6 or 9 named plaintiffs. It's to do this for a group of people. And therefore, we think your order is just fine. And I suppose if it's within the scope of this court's ancillary jurisdiction, we could do the motion for class certification, but I don't know if it's even necessary, because we're asking for an injunctive relief on behalf of the people of the state of Nevada. And therefore, you've issued your order accordingly. It doesn't really require similarity, commonality, or anything like that. That's determined later if and when the injunction is not obeyed. And a writ is just an affirmative injunction. It really just is a mandamus. It's do something instead of not do something. But it's the same thing as if you had a statute and you declared it unconstitutional and they kept enforcing it. That's a violation of your order, whether it's the same people or different people. It's not unconstitutional for some and constitutional for others. It is unconstitutional. So yes, we're doubling down. I guess we can move for class certification, which I don't know how they could oppose it, but that's where we're at on that issue.
Okay, thank you. And I'm not inviting an oral motion for class certification, nor am I prepared to state now whether the court believes it would have even jurisdiction at this point, not because of the cross appeals, to even decide that. But I understand plaintiff's position, and I'll deem that to be the response to Mr. Whitney's objection to non-party witnesses even testifying at a hearing like this. But before I make a decision on that, Mr. Whitney, is there anything else you would like to add at this time?
Nothing else at this time, Your Honor. Thank you.
All right, thank you. The objection to the testimony of the three witnesses, assuming they're all non-plaintiff, non-named plaintiff witnesses that the plaintiffs believe will be informative to the court as to their entitlement to be paid benefits, but yet have not received benefits, allegedly in violation of the writ of mandate. Based on that, the objection is overruled. The witnesses may testify. Ms. Boyd, I appreciate you listening to us. At this time, I'm going to have you raise your right hand and take the oath of witness, which my court clerk will administer to you, and then you'll be answering questions under oath. Ms. Clerk.
You solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Ms. Boyd, before I let counsel for the plaintiffs ask you questions, I want to ask you a few preliminary questions. First of all, is your last name Boyd, B-O-Y-D, ma'am?
Yes.
All right. And what county and state are you calling in from?
Washoe.
Okay.
Miss
And,
Washoe?
all right. And can you hear everything the court has said?
Yes.
All right. Thank you very much. Ms. Jones, you may proceed.
Thank you for testifying today, Ms. Boyd. During the course of your testimony today, we're going to talk about your claim with D.E.T.R. D.E.T.R has a confidentiality agreement with claimants. And in order to testify today, do you waive that confidentiality agreement?
Yes.
Is that what you were going after, Greg?
Yeah, I just wanted to make sure that either she was going to voluntarily waive the protections under Chapter 612 or the court was going to find that it had been waived. And I wanted to make sure that happened at the outset before she kind of got too deep. So thank you, Ms. Jones, for taking care of that.
Yeah. And Ms. Jones, let's please be a little more formal. Please proceed.
Thank you. Is Ms. DeGaynor able to do the screen sharing for exhibits?
No, I'm unable to do that. Usually that's handled by counsel when you are presenting an exhibit.
Oh, no. I have screen share capability.
Okay.
That was my question. I apologize.
Well, don't start screen sharing until you tell the court what you plan to do and get the court's authority to do it after I give the state an opportunity to be heard.
Thank you. Ms. Boyd, can you tell us why you're here today, why you're testifying?
I got a little bit of my unemployment and then it just stopped. And I've never got any explanation of why. And I'm hoping to get them to continue to go back and pay me like they should have done all along. I'm just really confused on what happened.
Did you provide counsel with any of your portal documents?
All of them.
Your Honor, I would like to ask that Exhibit 1, which has been previously provided, be entered as an exhibit so that Ms. Boyd can talk about the documents that are part of her portal.
Thank you. Mr. Whitney, any objection to the publication of Exhibit 1?
Your Honor, no, those look like those documents all came from.
All right. Any objection to their being admitted?
No, Your Honor.
All right. Exhibit 1 may be published and admitted. You may proceed.
I have pulled out what has been marked as Plaintiffs Petitioners Exhibit 1. Ms. Boyd, can you see that?
Yes.
Your Honor, can you see that?
Yes, thank you.
And Mr. Whitney, can you see that?
I can see that. Thank you.
Could you explain how you first applied for benefits?
I applied over the web for my unemployment in June.
When did you receive your first payment?
I also received it in June. But after that, I didn't receive any other payments or no explanation about anything. They sent me one payment of $9,400, I believe is what it was.
Just
it was given to me on a debit card.
Okay, some preliminary questions. Miss Boyd, what do you do for work?
I clean.
And do you receive a W-2 or are you what's called a private contractor?
1099 private contractor. And
Did you, oh, I apologize.
go ahead.
Did you receive any W-2 income from January 1, 2020 to the present?
No,
Did you receive any W-2 income between January 1, 2019 and December 31st, 2019?
no,
So when you say you're a private contractor, I'm going to assume you mean that you only receive 1099 income. Is that correct?
correct.
When you provided your portal documents, did you provide all the documents that you had access to on your portal?
Yes.
I believe you said that you received your first payment in June. Is that correct?
Yes.
When did you apply?
I applied in June, probably about a week prior to that.
When did you stop working?
I stopped working in end of January, beginning of February of 2020.
I'd like to draw everybody's attention to the document that I have on screen here. It seems like, Miss Boyd, do you recognize this document?
Yes.
And what is this document?
I believe it's where there's this claim summary of my payment.
Okay. Right here it says 1. Do you know what that is referring to?
Oh, it's, I guess, the first payment that my first claim and the first payment they were paying me from.
Have you continued, you said you didn't apply until June. Do you know why it says February 8th?
They backdated it, I believe, because it asked me when was the last time I worked.
Okay. I'm going to.
So to my understanding, they backdated it and then they paid me all at once for week 1 through, I believe it's 21 or 22 was the payment I received in June for those weeks that I made claims for.
It's difficult to see with these screenshots, but Miss Boyd, can you see the page that I have up on the screen there as payment summary?
Yeah, I can see it.
It seems to have these headings here that shows the week number, the week ending. Do you know what WBA means?
It's part of my unemployment benefits.
Okay. Do you know what earnings claimed means?
Yes, I believe I know what it means.
And what do you believe it means?
It means that anything that I might have claimed during that time of eligibility, I believe.
And do you know what total deductions means?
Yes, that's usually my taxes and stuff that are taken out.
How about stimulus amount?
That's the special thing they gave people because of the situation. They were giving extra money for certain weeks for the COVID.
Okay, and here it says payment amount. Do you know what that means?
That would mean a total of everything put together would be the total payment that I'm supposed to receive.
Do you know what this payment type means?
It meant you get paid by check. I believe is what the other one said, partial check or.
And how about the transaction number?
That was the transaction number of their, like when they paid me all at once, it was the same transaction number on all of them because it was in one payment.
Okay. It's difficult because we can't see those headings anymore, but we talked about that first one is as your week claimed, the date, your amount, whether you had any work in that week, your taxes withheld, if you received any of the $600 stimulus, the actual amount you were paid. It says your taxes were withheld. And then do you know if this number is the check number you received or the transaction number?
It could be the debit card number that they put it onto.
And you indicated that you received a lump sum, correct?
Correct. And it was weeks, I believe 1 through 21 or 22 that they paid me for all at once.
So this has weeks 1 through 7, and then we have 8 through 14, all the way up to 20, which I believe you said that's when you got your first your payment, correct?
Correct.
And those all have that payment number of 21126.
Correct. Yes.
Have you received any payments since that June 20th?
No.
Number?
Nope, just the one payment.
Have you continued to file weekly claims?
Yes, I'm up to, I think, 42 claims now, or 43. One or the other.
Okay. Has D.E.T.R ever sent you any information about requesting additional information or anything like that?
No, actually, I kept calling the assistant line from the phone number I'd seen that we were supposed to call, and I spent thousands of hours calling them. When I did get a hold of somebody, they gave me different things I needed to give, like the front and back of my driver's license, social security card. Then they asked for me to write a statement that I didn't leave the country. And then when I still didn't get it, I kept calling. And when I was able to get a hold of them, I was like, okay, what is it you're going to ask for next? And one of the girls got a laugh. She goes, they haven't told us what to say for this week yet. I mean, it was kind of offending to me because it was like they were just telling people whatever D.E.T.R was telling them to tell us, but we are never really given any information of why we're not getting it, or it was just, it's been extremely frustrating.
I have no further questions, Your Honor.
Thank you. Mr. Whitney, cross-exam.
Just really briefly, Your Honor. Ms. Boyd, do you remember applying? This is Robert Whitney, and good morning. Do you remember when you applied for the P.U.A benefits?
Do I remember when?
Yes.
Yeah, that was in June.
And do you remember filling out the form, the self-certification form?
I believe so, yes. It's been a while, but yeah, I believe so. I filled out anything that I was asked to fill out. I complied by giving them all the documents that they said we were going to need for it to apply.
Well, hold 1 second. Mr. Whitney, do you need the screen share during your examination, or can I have that pulled down? All right. Thank you, Ms. Jones. All right, please continue.
Thank you. Do you remember, Ms. Boyd, being asked the last date you performed work on that form that you filled out for the benefits?
At this right now, I'm not sure what the form said. it's been too long.
Would it surprise you if you had reported your last day of work on that form as April of 2019?
It only wouldn't surprise. I mean, that's the last time I worked, and I got a 1099 because I was working as a janitor for a church, but I was working past that, so I probably didn't quite understand the question. I thought it was asking me about the 1099, the last date that I worked, because that's the last income tax that I filed. The other jobs was just private people that I worked for over the years.
And the private people you worked for over the years, did you have any proof that you actually worked for those people?
I could get it if you would like me to, but no one's ever asked me for it.
But it wasn't submitted as part of you didn't submit that as part of the application process?
I didn't believe I had to ask because I was getting minimum. That's what they determined in the determination letter that you'd sent me with, I guess, what information I had given you.
Well, thank you, Ms. Boyd. Those are all the questions I have.
Okay.
Redirect.
I don't have anything further, Your Honor.
All right, well, before we thank and excuse Ms. Boyd, because sometimes it's better to do it while it's fresh, while the witness is still on the stand. The court's getting the sense from the questions. Well, let me back up. Here's what the court thinks Ms. Boyd just said: that she works in the cleaning industry, that she submitted an application for benefits in June, that she was paid in June. She was paid about $9,400. The $9,400 appears to be this sum total of the amounts from February all the way to June. Some of them $181 a week, some of them $700. But anyway, it ended up $9,400. And she received benefits in the form of a debit card. That was the singular receipt of any benefits that she acquired. She has continued to weekly submit applications for payment. She has, there's been no testimony about this, but I haven't heard that anybody believed that her situation involved clear and convincing evidence of fraud. I'm not understanding that anyone is suggesting she had excess earnings that would otherwise disqualify her from receiving continued benefits. And she has not appealed, apparently, or had an appeal set, much less heard. So I'm getting from the state that there might be issues with her initial application, which when somebody took a closer look, believed that she might not have provided all the necessary documentation to justify payments to be made. What I'm hearing from the plaintiff is she received payments and she checks all the boxes in the court's order of mandate, so she should have continued to be paid until and unless she was advised that it was going to stop, and then she could have availed herself of an appeal. So let me start with you, Ms. Jones. Is that what you're asking the court to take away from Ms. Boyd's testimony?
Yes, I did want to ask. Thank you, Your Honor. I did want to ask Ms. Boyd. Did you try to appeal at all, Ms. Boyd?
I didn't, because my claim, I kept putting it in, I kept accepting it, and I thought appeals was once they denied you, then you appeal it, but I was never denied.
Okay, thank you. Yes, Your Honor, I do agree with what you said.
All right. Well, what I said was what the court's to take away from this. So, Mr. Whitney, what would you like the court to know? I mean, it sounds like, based on your questions, that there might have been some errors or confusion or other information that might have rendered her ineligible for the amounts or at the times, and so do I have that right so far?
Your Honor, yes, I agree with you. You do have that right so far. We do have a witness that's coming up to testify about this, and we also have an exhibit to go with it that we submitted. one thing, Your Honor, I don't know if I should bring this up now. I'm going to have to get somebody we're going to have to maybe break for a little bit when the state presents its evidence, because I'm not quite sure how to set up the screens. This is a little bit different system, how to set up the screen share on this particular system.
Okay.
I know all my witnesses have the exhibits. I know petitioners have the exhibits. So perhaps maybe I could get away, maybe it might not be necessary to use the screen share.
Well, yeah, so here's the answer to that. Yes, we'll take a break, and I want to make sure everybody is not held, that nobody's held back by technology challenges. So I want to make sure anything you want the court to review and consider, you have the opportunity to present. But let's assume for a moment that the evidence will show that Ms. Boyd, with respect to her application, the application was either incomplete or on closer inspection reveals she wasn't entitled to the 9,400 she got in June, or that there was missing information, or that she hasn't explained why it looks like she may not have worked since April of 2019 and therefore might not have a COVID-related reduction in income. One of several different reasons why she might otherwise not be qualified to receive benefits. With respect to the court order that if somebody began to receive them, is continuing to make the weekly application for payments, is not making too much money to price them out of the pandemic unemployment assistance payments, and there's no clear and convincing evidence of fraud. What should I know with respect to Ms. Boyd? I mean, did the state have any evidence that her application was fraudulent?
Your Honor, it depends on. Well, no, I'm going to say there's no evidence that it's fraudulent. The court did hit on one of the points that our witness will expand on later on this afternoon, and that is, as the court is aware, to get P.U.A, your employment's you're going to have to stop working your substantial impairment to your employment to be eligible for P.U.A.
Yes.
It's saying that they haven't worked since April of 2019. That's well before P.U.A.
Well, no, but again, we're not here. I'm not an appeals officer or a hearing officer where somebody is challenging the denial of benefits. If I'm an appeals officer and if somebody says I deserve benefits and the state says no, you don't, or you don't deserve them in that amount, or you don't deserve them for that period of time, that's an apple. But what we're here to do today is an orange. And the orange is to decide if somebody who began to receive payments and then had them stopped, it was stopped for one of the reasons that the court believed would justify them being stopped. But failing one of the reasons that the court's order of mandate addresses, the payments should have begun again until and unless there was a hearing where all this could be, reviewed and considered. But all right, I think so. Before we thank and excuse Ms. Boyd, Mr. Whitney, do you have any other questions for her in light of the fact that I just gave Ms. Jones an opportunity to ask another question regarding an appeal?
No, Your Honor, thank you.
All right, and Ms. Jones, based on any of the court's comments, any further questions?
No, thank you, Your Honor.
Okay, Ms. Boyd, I want to thank you for being here this morning. In a moment, we're going to de-promote you, and so you can observe and watch if you want to, or go do other things and learn what happens at a later time. So thank you very much for being here, and wish you good health during this holiday season.
You too. Thank you.
Thank you. Ms. Jones, please call the plaintiff's next witness.
Thank you, Your Honor. I would like to call Steve Kohlsnik as plaintiff's second witness.
Thank you. Ms. DeGaynor, when you see him in the waiting room, please promote him to a panelist. And would you please state your name?
Stephen Paul Kohlsnik.
All right, thank you very much. Ms. Clerk, would you please administer oath of witness to Mr. Kohlsnik?
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may put your hand down, Mr. Kohlsnik. At this time, I'm going to invite Ms. Jones to ask you some questions Ms. Jones, please proceed.
Thank you. Mr. Kohlsnik, during the course of your testimony today, we're going to be talking about your claim with D.E.T.R. D.E.T.R has a confidentiality agreement with claimants. Are you willing to waive that confidentiality so we can speak freely and openly about your claim?
Yes.
Thank you. When did you first apply for benefits, Mr. Kohlsnik?
I applied for UI benefits the end of March, and that claim was denied March 31st.
And how did you apply?
On the D.E.T.R UI website.
Did you provide counsel with documents from your portal to be used in the hearing today?
Yes.
Can you please explain to the court why you're here, why you had to apply for benefits?
After I was denied for that, I waited for the P.U.A program to become available at the end of May, and I applied for the P.U.A program at that time and was approved 2 days later on June 2nd.
You indicated that you applied for UI first. What is your profession, Mr. Kohlsnik?
Sports official.
A sports officiant, like a referee?
Yes, umpire referee, yes.
Between January 1, 2020 and the present, have you done any work as a sports officiant?
No, official.
Official, sorry.
Yes.
Between January 1, 2019 and December 31st, 2020, did you do any work as a sports officiant?
Yes.
And were you paid with a W-2, like a paycheck, or were you paid 1099 wages?
1099s.
During the period of time between January 1, 2020 and the present, did you have any jobs where you actually received a W-2, meaning that you had a paycheck from an employer?
Yes.
When did that happen?
I was employed by Empire Restoration from December 2019 until March 13th, 2020.
And why did you leave Empire?
I caught the flu really bad from someone in the office, and I was out for 2 weeks, and by that time they had replaced me.
Okay. And in January 1, 2019 through December 31st, 2019, did you have any other jobs besides Empire where you actually received a W-2 or a paycheck from an employer?
Yes.
And when was that?
October to early December.
And where were you working?
Walmart Distribution Center.
Did you provide your W-2 income to D.E.T.R when you first applied?
Yes, I did.
And did you provide your 1099 income to D.E.T.R when you applied?
To the P.U.A, yes.
So just to be clear, you first applied for UI based on the fact that you had W-2 income.
Yes.
And why did you end up then changing over to P.U.A?
Because most of my income from 2019 was from sports officiating, and I qualified for that program based on their guidelines.
Did you ever receive any payments under the UI program?
No.
Do you know why?
I was denied. My claim was denied.
And that's when you applied for P.U.A?
Well, that was a couple months later when the program actually finally became available in the state of Nevada.
Okay. And did you ever receive a P.U.A payment?
Yes.
When did you receive a payment?
June 16th.
And how many payments did you receive?
That one and 3 more.
Did you provide, can you see that on your portal when you go on your claim?
Yes, there's a summary of all my weekly certifications and when I was paid and what I was paid.
Your Honor, I would like to offer into the record what has been previously marked as Plaintiff's Exhibit number 2, Mr. Kohlsnik's portal documents. may we go ahead and share those now?
Not just yet. Mr. Whitney, any objection from the state?
No, Your Honor.
All right, they may be, they're admitted and you may publish them. Go right ahead.
Mr. Kohlsnik, can you see the screen I am sharing?
Yes.
Your Honor, can you see the screen?
Yes.
And Mr. Whitney, can you see the screen?
Yes.
Thank you. I'm going to try and get this so we can see it a little bit better. Mr. Kolesnik, is that what you were talking about? About you made a motion with your hand that you could see your claims? Is this the document you were speaking of?
Yes, it is.
I'm going to scroll down a bit for everyone to see. It says the weekend, the last week there, it says 37, dated 11/21/20. The other page includes, so we go from 28, scrolling down to 3, scrolling down to 1. Again, when did you apply for P.U.A. benefits?
May 31st.
It says here, number 1, 3/14/20. Do you know why your first week is indicated as 3/14/20?
I had W-2 earnings that week.
Okay. And then how about the next week is 3/21? That was before you applied for P.U.A. Is that correct?
Yes.
Do you know if your claim was backdated?
Pardon me?
Was your claim backdated that you know of?
Yes, it was backdated to the first week I was eligible for that program.
And was that something you did yourself or something D.E.T.R did?
When I filed my P.U.A. claim, it prompted me to go back all the weeks that I was eligible, which I did. So I filed a weekly certification claim each week back to that date, 3/21.
Okay. And since that date, have you continued to file weekly claims?
Yes.
Have you ever received anything from D.E.T.R saying that they needed additional information or any fraud determinations or anything like that?
Not by a document, but yes, over the phone.
And explain to us what happened.
Well, I called the P.U.A. 800 number and I finally talked to somebody and I was told I'm just referring to my dates here, that I may have been denied and I needed to upload my UI denial letter, which I did on 9/9. Then I spoke to another rep on 9/16, or excuse me, on or about 9/24, and she said, now you have to upload your driver's license, social security card, and proof of residence, which I did at that time.
Did your payment start back up?
No.
Did you appeal the fact that you weren't able to get any payments?
Yes, I appealed on 8/5/20, and as of this morning, that appeal has not had an initial review.
Okay, let me hit the pause button because I'm confused on the dates, Mr. Kohlsnik. Here's what I am led to understand. You applied either May 31st or June 2nd when your understanding is Nevada had then stood up its website to allow P.U.A. applications to be submitted. Do I have that right so far?
About May 31st, yes.
On or about May 31st?
Yes, and approved on June 2nd.
Approved on June 2nd. And
Yes.
so on your May 31st application, your application was to go back in time to the date in March where you stopped receiving W-2 income. Is that
Yes,
right?
that's correct.
All right. So again, the June 2nd date is when you received a payment?
June 2nd is when I was approved for the P.U.A. program. June 16th, I received the first payment.
All right, hold on.
Okay.
And was that a fairly large amount? In other words, like Ms. Boyd, did it include, several weeks worth all at once? So backdated amount, or was it just a week or two?
It was a large amount, including all the backdated weeks.
All right. So what to your memory, about what amount was that you received on or about June 16th?
A little bit over $11,000.
All right. So then I stopped you, so I'm going to unpause. So then what happened? When did you continue to apply weekly after that?
Yes,
And at some point you got through to the P.U.A. helpline and were told to load your UI denial letter and then thereafter to download your driver's license, social security, other identifying information?
yes, this is after the payment stopped.
Okay. Then when did you, sorry to hijack your examination, Ms. Jones, but I want to make sure I got what he said already. Did you say then that what happened on August 5th? I thought
August 5th, I filed an appeal for my P.U.A. disqualification determination.
All right. So when did you receive a P.U.A. disqualification determination?
August 3rd.
And what did they tell you was the reason?
I may have other program eligibility.
And what did you understand that to mean? UI eligibility or something else or what?
UI eligibility, yes.
And you believed, I guess, that they were wrong because you'd already received the UI disqualification letter?
Denial letter, yes.
Denial letter? All right.
Yes.
So you appealed that on August 5th?
Yes.
Right?
Correct.
Has a hearing date been set?
No, it's still awaiting initial review.
All right. So then what happened on 10/16? Because I thought you indicated you received some more money October 16th and then three payments thereafter.
No, my first payment was June 16, and I received 3 more payments each subsequent week after that up until July 5th.
Okay, so the June 16th was the big payment of
Yes.
about 11,000, and the 3 payments after that, were they weekly?
Weekly, yes.
And about how much were those each?
$934.
All right, then they stopped
Yes.
because you received a notice that you were ineligible for P.U.A.
I received that notice about a month later on 8/3. Yes.
All right, and then you appealed that and you're waiting to have that appeal heard.
That's correct.
All right, have you continued to file the weekly applications for benefits even though you've been told you're no longer eligible?
Yes, up until and including the last Sunday, 11/28.
All right, I think so I'm up to speed now. Ms. Jones, you can continue and ask the witness any additional questions. Thank you for indulging me.
Thank you. Have you ever been able to talk to an adjudicator or any referee of any sort since your payments have stopped?
No.
Did you ever receive a letter saying that you had any fraud questions or anything like that?
No.
That's all I have, Your Honor.
Thank you. Mr. Whitney, cross-exam.
Just really briefly, Your Honor. So, Mr. Kohlsnik, your testimony is your payments were stopped and you did receive a letter from D.E.T.R telling you that you had other program eligibility?
Yes.
Okay. And it's you're saying that you've never been advised by D.E.T.R to file in UI anytime after you receive that denial of P.U.A. benefits?
I did file another claim with UI right after that, yes.
Thank you, Your Honor. No further questions.
Well, okay, thank you. And Mr. Kohlsnik, you did that even though you had been denied because why? You wanted to make sure out of an abundance of caution that was not what was holding things up?
Yes, sir.
And was that denied also?
It wasn't directly denied, but I got a message on my portal website that said, you need to discuss your claim with a D.E.T.R representative. You need to call in to the office and talk to someone before we can proceed with your claim.
All right, did you do that?
I did that every day for 2 straight weeks, almost 500 calls a day. I never got through.
And
at that time, oh, go ahead.
Was that in the July timeframe?
It was in August, right after I filed my appeal. And then 2 weeks after I filed that claim with UI, it disappeared off my portal dashboard. without being denied or approved.
Okay. Let me think for a moment here. You received payment, the big payment, 6/16, and 3 more after that. So end of June, and then early July. Is that fair?
That's correct.
So the order of mandate from the court was July 23rd, Mr. Whitney. So again, before we thank and excuse Mr. Kohlsnik for his time this morning, again, because I'm gonna ask about this during the summary here after all the evidence is taken. What is your understanding of the reason that Mr. Kohlsnik hasn't been paid, assuming the court finds credible his testimony, that he hasn't been paid, notwithstanding the court's order of mandate, which came out after he had received some payments, but then they stopped? Why then, if the court accepts that factually to have occurred, what's the state's explanation for why his payments would have stopped?
Your Honor, this is one, again, it's April 1620. The court's probably remembers that when a person is being paid in P.U.A, their eligibility is contingent upon the person not being eligible for one of the other 3 programs. And so if the EPLs also say payments to stop if that claimant becomes eligible for one of the other programs. So I guess the overall big picture here, my understanding is that's what happened in this case.
Okay, well that might explain why he wouldn't be eligible, but I guess I want to be more pointed here, because this might be a reoccurring theme, or it might not. But why did payments not resume to him, notwithstanding what you just said? That he might not otherwise be eligible, that he might have UI benefits, why did payments not resume to Mr. Kohlsnik these many months after the court specifically ordered them to begin again on July 23rd? I mean, this is not a mystery question. This is why we're having this hearing. Obviously, the state, both sides have given this a lot of thought in anticipation of this hearing, because these are the tough questions that the court was going to ask to make a decision whether there has been a willful failure to abide the court's order or there's been substantial or complete compliance. Nobody is suggesting there's been complete compliance, which is the gold standard, but I'm looking for at least the silver standard, which is substantial compliance. So again, Mr. Whitney, if the court ordered it to be restarted again, notwithstanding these concerns of his eligibility, why did that, to your best of your knowledge, not happen?
The best of my knowledge, Your Honor, that it puts D.E.T.R in direct conflict with U.S. Department of Labor guidance, which it is required to follow. I do if my understanding is correct also, and our witness will testify to this, Mr. Kohlsnik can apply for UI benefits there, but I'm sorry, to address your question.
That may well be true. He might have UI benefits available, and in the ordinary course of things, he's not eligible for P.U.A. benefits until and unless he fully exhausts the UI. But that's a bridge that we've already crossed, and right now we're in has the state complied with the order or gotten the order modified, state or otherwise held in abeyance? Okay.
Your Honor, may I add one point on this thing?
Well, only if we agree that I'll allow both counsel for the state also to address the court in the middle of a witness. But so go ahead, Mr. Thierman.
Just so you know, there's a CFR regulation, 20 CFR 625.10A, which applies to P.U.A. as well as it applies to disaster unemployment insurance. And it says any decision of a DUI first stage appeal must be made and issued within 30 days after receipt of the appeal by the state. They received an appeal, 30 days went by. They haven't responded. I don't think that the fact whether or not their objection to his not, his eligibility or dual eligibility or whatever has been waived by not offering him and not issuing a written decision within 30 days of his.
Well, I'm not here to decide that. That's a different issue for a different time. We all know, I mean, it's not lost on the court that it took a while to get people trained to handle these appeals, that the state is, from what the court understands, can take judicial notice. They're trying to move that forward as quickly as possible. As a matter of law, if somebody has waived the right to decline benefits because the appeal didn't happen timely, that's another decision for another judge at another time. What I want to, again, let's all keep our eye on the ball here. And the ball is, has the state willfully and knowingly violated the court's order? And again, a reoccurring theme here is, and again, we just started, but it seems to the court so far, the theme is these people are not eligible for benefits, or we have concerns that they're eligible, or they might be eligible for something else. And that may well be true. And that may be the ultimate determination. But the court order was very specific. The fact that they may later be eligible or not eligible was no moment because the court ordered certain things to be done by a certain date. So that's what I'm here to decide. All right. With that, Mr. Whitney or Mr. Ott, anything else from the state before we thank and excuse Mr. Kohlsnik?
I just have one or two more questions, Your Honor.
Go ahead.
If I could.
You may go right ahead.
Mr. Kohlsnik, Greg Ott for the state. Couple questions about your the second UI application that you said that you filed. Can you tell me the date that you filed that?
Right after I filed the appeal for the P.U.A, so on or about August 5th.
And you never received a denial or a approval of that? Was that your testimony?
That's correct. A little pop-up message popped up and said, you must call the D.E.T.R office and speak to a representative.
And then it just disappeared? Was that your testimony?
After about 2 weeks, that claim disappeared off my dashboard. Yes.
So have you ever had that happen with a D.E.T.R claim before, where it just disappeared with no sort of
no
disposition?
No.
Did you ever try to refile it?
I did. The next day after it disappeared, and the same thing happened.
What was that day? What was that day that you tried to refile?
That was about the middle of August.
So sometime 15 to 20, somewhere in there?
Somewhere in there, yes.
Okay. What happened that time?
Same thing happened. Told me to call in and speak to a representative. Could never get through. And then after about 2 weeks, that one disappeared off my dashboard.
And did you try a third time or no?
No.
Did you get any sort of confirmation that your claim had been submitted from D.E.T.R or accepted either of these second two times, the August 3rd or the August 15th?
So we're talking about the UI application, correct?
No,
Correct.
I never received anything from them.
Are you saying that you did see it on your dashboard after you filed it, though?
Yes.
How long did it appear?
Approximately 2 weeks.
Is that true in both cases, the August 3 and the August 15 to 20?
That's correct.
Okay. Is it possible that you didn't hit submit and it never got sent in?
On my end, I filed it and I submitted it, and that's the message I got. So I'm not sure what happened on D.E.T.R's end.
Okay. And sorry if I asked you this. Did you file a third? You said you did not file a third time, correct?
Third time, yes.
You did file a third time. What happened the third time?
The first initial time back in March, and then the 2 additional times in August.
Yeah, thank you for clarifying. I apologize for the loose language. So you filed the initial time, then August 3, and then August 15 to 20. But when the August 15 to 21 disappeared, you did not file again, correct?
I gave up on it.
I don't have anything further, Your Honor.
Thank you. Anything else, Ms. Jones or Mr. Thierman?
No, thank you, Your Honor.
All right, thank you very much. Mr. Kohlsnik, the court thanks you for your time. You're excused. You can observe the rest of the hearing if you'd like, and to you and your family a safe and healthy holiday.